Michael James.
Thank you, Mr Streeter. I thank honourable members for thoughtful contributions, and we certainly agree with the need for a transparent system of rights over people's personal data and a system of enforcement of those rights. We couldn't agree more with the thinking behind that, but we do believe that we need to pause for thought before implementing Article 80(2). And the GDPR represents significant change, that we should test the effectiveness of the new enforcement scheme, including, as we've already discussed, Article 80(1), before we make further changes of the type proposed this morning under Amendments 154 and 155. Amendment 154 applies Article 80(2) with immediate effect and gold plates it. We have a number of concerns with this approach. Firstly, we are very wary of the idea that data subjects should be prevented from enforcing their own data rights simply because an organisation or an individual, in this instance, that they had never met before, got there first. We consider this not to be acceptable, and that it contradicts the theme of this bill and the GDPR as a whole, which is to empower individuals to take control of their own data. And as yet, we have no evidence that this is necessary.
Sorry, on that point, I'm grateful to the Minister. Let's take one of the 200 data breaches which are listed on Wikipedia. Let's just take Uber, for example, which was one of the most recent. 57 million records leaked. How is one of those drivers seriously going to take Uber to court to ensure justice?
Michael James.
The GDPR places robust obligations on the data controller to notify all data subjects if there has been a breach, which is likely to result in a high risk to the data subject's rights. And this is almost unprecedented and quite different. Yes,
it's not unprecedented. Look at the Wikipedia page on data breaches. There are 200 of them. Uber, Equifax, AOL, Apple, Ashley Madison, Betfair. I mean, the list goes on and on and on. The answer that I want is to this very simple question. How is a humble Uber driver who is busting a gut to make a living, how are they seriously going to find the wherewithal to hire a solicitor and take Uber to court? What is the specific answer to that question?
Michael James.
If a data subject is sufficiently outraged, there is nothing to stop them contacting a group, such as which, to enable them to opt in to a group action. Furthermore, the ICO have a range of enforcement power options open to them to require companies they can issue enforcement notices that can compel the controller to stop doing something in breach of people's data rights. And as I said, there is nothing to stop the data subject opting in to a group action.
On that point. So we know there is only kind of one major precedent of the kind of scenario which she has sketched out today, and that is the scenario of various claimants versus Morrison Supermarkets, which is a case that she will know well. And that was a case that illustrates the difficulties of opt-in. It's by far the largest group of data protection claimants ever put together. And even then, the total number of people that could be assembled was 5,000 out of 100,000 people who had their data rights breached. Now, that in itself was incredibly difficult. It took a huge amount of time. And even if the claim succeeds, 95% of people, those people not covered in the claim, will not receive justice. So I'm not quite sure what new evidence the Minister is waiting for in order to have enough evidence to activate the kind of proposals which we're proposing today.
Minister.
Well, as I said, the GDPR represents significant change, and we believe we should test the effectiveness of the new enforcement scheme before we make further changes of the kind that he is suggesting. And in respect of the Morrison's case, it was effective. The collective address mechanism, group litigation orders, was used. It was effective. There will be additional powers open to the Information Commissioner under the new legislation to further enforce companies to take action when there has been a breach of data. If I may return...
Mr. Liam Byrne.
Very grateful. Well, I'm incredibly disappointed with the Minister's response, and actually I'm not quite sure I believe that she believes what she's been reading out, and I hope that between now and report stage, or when this amendment is pressed, she might have the opportunity to consult with both Which and indeed with her officials. The reality is, in complex public policy decisions now, whether it is organ donation or auto-enrolment pensions, we now have well-established procedures of opting out rather than opting in. This is something that there has been quite strong cross-party support on over the last 7 or 8 years. It reflects actually a reality in new economic thinking around behavioural economics that opt-out is often better than opt-in. But if the Minister is going to pursue this line of argument through report and into the other place and through to royal assent, I have to say to her, we will not permit her ever again to refer to this bill as a gold standard in data protection. It is a pretty shoddy, tarnished bronze, because what she has sought to do is ensure that the legal playing field is tilted in the favour of large organisations and tech giants away from consumers and away from children. And that will be a pretty poor state of affairs. We now have enough precedents to know that the regime that she is proposing will not work. This is not a theoretical question. This is a question that has been tested through the courts already. And the proposal that she has just will not fix the asymmetry by which potentially millions of people are left without justice. And the idea that she can present the Morrison's case as some kind of success when 95% of people who had their data rights breached did not receive justice because they did not opt in to the class action, I'm afraid betrays it all. She is proposing a system of redress that is good for the few and bad for the many. And if that's her politics, so be it. But she will not be able to present this bill as the gold standard if that is a line of argument she persists with.
Well, thank you. And as I say, we'll come to divide on that amendment later on in our proceedings. But for now, it's Amendment 115.